Hey, this is Chuck Krugel again. You're here for number 4 in our protecting employee assets, the life cycle employment relationship, or our employment law boot camp. And this is leave of absence and medical issues. Again, I'm the moderator of this webinar and of the entire series. And this is part of Financial Poises series. Slide number 4 on the PowerPoint, which is on the screen, is our typical disclaimer that we're not your attorneys, you're not our clients, and you can't go out and make important business decisions based on what you hear today or what you learn. We're just here to help you understand the issues and how to select and work with your own advisors or attorneys. Also, we won't be lecturing off the slides, but we will be referring to the slides. So as we go along, you may want to try to track what we're talking about relative to the slides. Really, or more so, this is a discussion among the 4 of us about today's topic, and is more about financial poise on slide number 62 of the PowerPoint. As always, our panelists are Max Barrick, partner with the Garfinkel Law Group, Helen Black of the law offices of Helen Black, and Amit Bindra of the Prinz Law Firm. You can find out more about us on slides 57 through 60. Our bios are up there. And if you're attending the live premiere of this webinar, you can submit questions using the web portal that's being monitored. And if you're watching us on demand, you have questions after the webinar, you can send an email to info@financialpoise.com. Just include your question, the name of the webinar episode, and we'll do our best to get you an answer ASAP. And thanks to our sponsor, the National Law Review, on slides 3 and 61. And with that said, let's get into the substance of all this. Helen, what are some of the laws we're going to be talking about today, or that the employers can expect to deal with relative to leave of absence and medical issues?
Sure. Well, the answer to your question depends on how many employees the place of employment has. And so, for example, if an employer has 50 or more employees within a 75-mile radius of a work site, you're going to be dealing perhaps with the Family Medical Leave Act, which we'll get into in further detail in this webinar. If there are at least 15 or more employees, then you are also going to be dealing with the Americans with Disabilities Act. And if there are less than these number of employees, you're probably going to be dealing with some various state laws. If you have 50 or over employees, then you could be dealing with all these laws, including any local or state laws that might apply to you, to your place of employment in the jurisdiction where your business is located or where your business has employees.
Sure, there's some counties and cities have their own, I guess, human rights ordinances. So,
Exactly.
right.
Most states have their own human rights laws. They usually have the word human rights right in them. And there are also municipalities that also have human rights laws. So you really have to check with your local state laws in addition to the federal laws, which are going to apply to everyone who lives in this country, assuming you have the number of employees that make the law apply to your business.
Are there any common themes or elements amongst all these varying statutes, that some sort of common denominators?
Yeah, don't discriminate.
Yeah.
But other than that, when you're talking about, for example, leaves of absence or medical, usually, like for instance, under the Americans with Disabilities Act, an employer cannot discriminate against someone based on the fact that they have a disability, or let's say they need some sort of an accommodation. So for example, let's say someone works at a place of employment that doesn't have 50 employees. And the reason why 50 is a magic number is because that's when FMLA family medical leave applies. And under FMLA family medical leave, if assuming someone meets eligibility requirements, then that person could be entitled to 12 weeks of job protected leave for a medical condition that qualifies for either them or a family member or a spouse. So for instance, let's say place of employment doesn't have enough employees for FMLA, but they have at least 15 employees, then as a reasonable accommodation under the Americans with Disabilities Act, you might have to give a certain amount of leave as a reasonable accommodation if someone does have a disability, or an illness that would ordinarily qualify for FMLA. So you might not necessarily have to provide the full 12 weeks that one would normally have to provide under FMLA, but you might have to provide some type of job accommodated leave as a reasonable accommodation under the Americans with Disabilities Act. And there's a whole analysis that goes into that type of a situation.
Thanks, Helen. So, Max, why do we have these laws to begin with? And our workplace is better off having these laws, or are we better as a society for having these laws?
Well, I have an old law school professor who used to say the FMLA exists solely to trip up and get into a world of trouble middle management and HR types, just because it can be so complicated. I'm a plaintiff's lawyer, but that said, so I suppose there's a bias to disclose, if you will. But I do, these laws are necessary, and there really is a reason we have them. I think to that effect, what I would say is, we want, at least on paper, and I realize there are some complicating factors in the world right now, but in theory, we want equitable workplaces where everybody has equal opportunity to move up the chain based on merit and without limitations based on things like health conditions, having a family, and what have you. And to be able to care for relatives. The Family and Medical Leave Act, the FMLA, as Helen helpfully explained, allows us to have these items in place. It's not applicable to every employer. The FMLA recognizes, as Helen laid out very helpfully, if you're a small company, you're very likely not going to be bound by this law, except if you create contractual rights. There is some case law out there that says if you put FMLA coverage in an employee handbook, even if you're not a 50-person company within 75 miles, you can create obligations. So maybe just something to keep in mind, always be reviewing that if you don't intend to provide the coverage. But we want consistent workforces, right? You want people to be able to predict when they'll have a job, when they won't have a job, what sorts of protections they'll have. It doesn't, on paper, add any salary burdens to employers. It's not paid leave, it's unpaid leave. It basically just says if you get hurt or you get sick or your covered relative or someone in the military is unavailable, we're going to protect that person's right to come back to work. There are plenty of limitations that exist for very specialized employees who the company just cannot spare, who earn and meet certain criteria. Small employers are not bound again. So I think, maybe somebody on the management side or who's got a more, I'll call it retrograde view of employment practices might disagree. But I think objectively, it's a good thing for people to know if my kid gets sick or I need intermittent time because my kid has sickle cell anemia or Crohn's disease, something like that, I'm going to be able to take care of my family or myself.
Yeah, I mean, personally, as a management side attorney, these laws have been enacted because there were bad things going on. I mean, it's a reaction to bad HR practices in management.
Right. You don't want, when I was a kid, I was an avid reader. Now as a lawyer, it's all I do. So I never read for fun anymore. I don't know how people who read books when they do what we do for a
For
living.
enjoyment, yeah.
Yeah, I don't know what that means. But I remember reading The Jungle as a kid. About the Gilded Age and meatpacking plants. And everybody missed the point of the book when it came out. I mean, we got the FDA, which was a good thing as well.
Upton Sinclair.
Right, but Upton Sinclair, his point in writing it was about the labor conditions. But I remember in reading that book, you could you break your leg, you get hurt.
Yeah.
They were happy to throw you out on your butt and find another immigrant who was healthy to just slide you into this low-wage, dangerous job and just replace you. When you got hurt and you weren't yourself when you came back, they were sort of sorry, you can't lift like you used to. And I think, we don't want to go back to a time where you go to the coal mine until they wear you out or you get sick or you get whatever.
Sweatshops.
Yeah, sweatshops. So I don't, I guess there's an argument against it, but these create minimum standards. They create some reliability for employers too, because now you're not at the mercy of disparate state, one state has this, another has that. There is a uniform federal standard and minimum that you can operate from that gives people a baseline of what their rights are going to be in this context.
4 years ago, quick note, 4 years ago, I taught a labor and employee relations class for upper class HR in the business school at Loyola University, and I assigned the jungle as for reading. And we discussed it a lot. Very good book in terms of discussing uh, early 20th century labor practices in the US.
It's a great book for a lot of reasons. That's one of them, and just sort of societal views on a lot of these issues generally,
yeah.
I think probably well depicted there as well.
Yeah, absolutely. Thanks. Amit, we discuss in greater detail some of the leave of absence requirements and the conflicts, like paid versus unpaid leave or partial compensation, loss of position due to layoffs.
Yeah, I think Max and Helen have talked about this a little bit as well. The Family Medical Leave Act is supposed to provide people with the ability to take leave depending on the type of company they're working at. So for bigger shops, leave for they have a kid or to care for a spouse, a family member like son, daughter, parent with a serious health condition, which is a key phrase there. Their own serious health conditions, military leave, or some other qualified reason. So it doesn't allow leave for everything, but it allows leave for certain segments of care that is necessary. As Helen mentioned too, there are other laws that are implicated as well. So there might be other reasons why people are allowed to take leave. So that could be leave consistent with the American Disabilities Act. It could just be general sick leave or PTO leave, depending upon what the circumstances are. And so that, I guess, leads to the next question of, is it paid or unpaid? Under the Family Medical Leave Act, it would be unpaid leave. And so the FMLA is really just designed as a way to allow people to take unpaid leave for pretty serious conditions or circumstances in their lives without having to lose their job or risk their job. It's not an indefinite period of time. There are caps on how long that leave exists, and it's not paid. However, there could be paid components to that depending upon what other laws are applicable. So for example, if someone's hurt in a workplace and there's workers' compensation laws that fill in, or a disability leave, or maybe someone's taking normal sick leave or PTO, those could fill in the gaps to allow it to be paid leave. They can run concurrently depending on the situation. So to some degree, it's the lawyerly answer of it depends on the local laws as well, but the FMLA would only allow for the unpaid component. Other laws may allow employees, or other policies internally within a company may allow an employee to take paid leave.
So yeah, you bring up like the other policies internally. I mean, can a company require an employee to use up paid time off for any of these leaves of absences?
Yeah, so there could be some substitution leave that, depending upon your situation, the paid leave has to be used first or concurrently with the unpaid leave. I think companies should be careful about how they approach it because, and we'll talk about this in a moment too, companies want to be very careful they're not interfering with FMLA rights or preventing someone from taking them or retaliating. But depending on the circumstances, there can be concurrent leave taken where the paid leave is also applied.
Thanks.
The one place where that might differ, depending on the state, is workers' compensation. When someone gets hurt at work and the injury arises out of in the course of employment, generally an individual is entitled to their state's workers' compensation. And in that situation, they would be entitled to the workers' compensation benefits, and they wouldn't have to use their paid time off for that, except for maybe a certain limitations period. With that said, though, there have been some case laws that have basically said, though, FMLA can run concurrent with the amount of time that a person is off of work for a work-related condition. So whereas with the work-related condition, that state system might pay benefits, it's not guaranteeing more than a certain amount of time off that would, let's say, exceed FMLA leave, for example.
Yes, that's a pretty touchy situation, and employers have to really stay on top of.
Yeah.
I guess their accounting and time off and things like that, so.
And again, that's only for a work-related injury. So, it doesn't apply to something that is unrelated to a work-related injury. So for instance, God forbid someone has, cancer or heart attack or whatever the case may be, then yes, an employer can require that they use, let's say, paid time off during a leave period.
So a lot of times during webinars, I like to ask questions that I have some idea what the answer is. Because this way, we have there's a backup, but I'm gonna ask a question and I don't really know the answer to this. If they're out on workers' comp, can you use their paid time off to make, because workers' comp is usually 66 2/3% of the regular rate of pay. Can you use paid
Tax-free.
time off? Tax-free, okay.
In Illinois, I think you're referring to Illinois. I don't know what it is in other states. But in
Okay.
Illinois, you are correct that when someone is off of work as a result of a work-related injury and they're receiving what's called temporary total disability, TTD,
Yeah,
it is 66 2/3 of the salary, tax-free. So if you think about it, it's about the same as the take-home pay because it's tax-free.
but the question though is, all right, so it's roughly the equivalent of take-home pay, but can they use their paid time off to make up the difference between like 66 2/3 and 100%?
So I guess technically, if they said to the employer that we rather use our paid time off, they might be able to do so, but you can't double dip. So you can't use your paid
Okay.
time off and get temporary total disability for the
All
same
right.
time, because then you'd be double dipping. Because essentially the employer, usually under these state laws, the way they work is that the employer is responsible for paying the employee that period of disability. So if they do use up their paid time off, that means the employer has already paid them. The employer doesn't have to pay them twice for the same amount of time off.
Cool, thanks.
But
That
sometimes
helps.
also, like, there might be a certain amount of time that you have to use up before, let's say, the temporary total disability would kick in. So for example, I'm most familiar with Illinois. You have to be off of work for 3 days before the condition is such that the temporary total disability would kick in. So if, let's say, you've missed 5 days of work, workers' comp might only pay those 2 days, and you might want to use, if you want to get paid and you have paid time off, you might want to use paid time off for the first 3 days of your work-related leave.
Great. Bill me later. Thanks. Actually, Alan, let's stick with you on this one too. What about vaccines? This was
What about them?
during the pandemic, COVID pandemic, those could be required. But what about now? And like for now, like the big controversy is measles. So
So honestly, because COVID was such a hot topic, we talked about vaccines probably ad nauseum and
yeah,
what accommodations can be made. But the law really didn't change. We were really applying essentially the same law to COVID. And here's what I mean by that. I've had businesses, let's say, were medical practices, and the medical practices wanted their employees to be vaccinated. And so we've already had a framework of the analysis for when can I require someone to be vaccinated. And the answer is no different than for anything else. If the employer shows that this is something reasonable and it's not being applied in a discriminatory fashion, they can have a reasonable work requirement, such as having a vaccine, being vaccinated. And the employee would need to show that either for religious reasons or for medical reasons, I need an accommodation. And like anything else, when you're asking for an accommodation, is it a reasonable accommodation? And is
Yeah.
that requested an accommodation? Would that pose as an undue hardship on the business? Vaccines are no different. You need to go through the same analysis. So with respect to measles, which might be more prominent today, an employer might say, look, reasonably speaking, let's say you're working in a daycare setting. This is something that is essential for the job, that we need folks to be vaccinated against measles and not to have this exposure. And we want our employees to be vaccinated as long as they require all similarly situated employees to be vaccinated. And then the employee might say, I don't want to have a vaccination. And the employer could say, okay, just not wanting to be vaccinated is not good enough. I'm going to terminate you. But then the employee says, well, gee, I have an egg allergy, or I have, something else that, medically speaking, I can't have these vaccines. All right, fine. Then the employer has to look into that and see if a reasonable accommodation can be made that doesn't pose an undue hardship on the business. Same for religion. People might say, you know, it is against my religion or my faith. And if it's a good faith belief, then again, you have to engage in that interactive process to see if a reasonable accommodation can be made for that individual to not have the vaccine and to do something else, like perhaps wear a mask or perhaps test or some other type of thing, as so long as it doesn't pose an undue hardship on the business.
What if the person says, like, I'm a snake handler, you know, and that's my religion? I mean, are we still required to, you know, to accommodate? And that's kind of, that's a little out there, I think, but
As long as it's a sincerely held
Mm.
religious belief,
Yeah.
then you have to engage in this process.
And,
Thanks.
and to that point too, I think some of the more successful cases relating to the COVID vaccine involving employees who didn't want the vaccine, those were typically folks who had previously said they can't take a vaccine. So they could demonstrate this is not just a COVID related issue, but for example, maybe they haven't taken the flu vaccine or other vaccines, because then they can demonstrate, or they did demonstrate, this was a sincerely held religious belief.
That's a great point. And also, I would say, you know, from the employer side too, I always advise, what have you done in the past? Like, what are your past practices relative to this? Because if you could show that you're being consistent with what you've done in the past and you've never had any legal liability or exposure for it, that I think that could improve your defense. It's not an absolute, but it helps.
Yeah, no, that's a good point too. I mean, to some degree, to a large degree, from an employer standpoint, you'd have to prove or establish that there is an undue burden to you to provide some accommodation to the employee, and you have to engage in that process. So the question then becomes, what would you have to do as an employer to accommodate that request? It could be simple as PPE, working from home, maybe other options. But if those are truly undue burdens, then that's not something the employer can necessarily do. So
Yeah.
it becomes this analysis of figuring out on both ends, what does the employee want, and then what can the employer do without it becoming an undue burden.
Thanks, Hannah and Helen. Um, Max, moving on with you. Can an employer like test or screen their employees? And even more specific, like, can they do things like take their temperature, or things like that?
That's a good question, Chuck. I'm gonna answer, but I want to step back. You know,
Sure.
and I think what Helen said about the interactive process was useful too, because at the end of the day, it really was the same analysis. It's just the direct threat component and some of the specifics had changed, but the tests themselves, I guess the one nice thing about the pandemic as it related to employment laws, at least as to the ADA, we already had a framework for dealing with a lot of these issues. You were just applying it in different contexts. And I think as the pandemic went on, you know, the nature of the inquiries changed, but the tests were always the same, right? You know, at the beginning, you had questions about, well, can I get a work from home accommodation, or do I have to be made to go into work when I'm high risk? And it was before vaccines were available or masks were widely available and all of it. And then it's, well, can I be forced to be vaccinated, or can they make me do this? And then, you know, et cetera. So I would say, you know, the EEOC at the time, which is not operating as it normally does, gave employers a fair amount of leeway under the ADA to conduct health screenings and impose certain return to work requirements for, I think, pretty obvious safety reasons.
Sure.
If you were COVID positive or unvaccinated at various points, you know, there were legitimate risks to your coworkers that could be created by you showing up and, you know, spreading your droplets on everybody, if you will. You know, afterwards, as the emergency declaration was ended, and we're going back to a more traditional framework. Again, the tests haven't changed, but they're being applied, I think, more traditionally now, which is if you're going to do health screenings, they have to be job related and consistent with business necessity, meaning that they're tied to the risks in your workplace and not just generalized concerns about people where it's like you're a nail. I'm trying to think of a good example. Maybe nail salon's bad because you're up close to people, but like you're working 50 feet from everybody, but you have to be, you know, at perfectly 98.6 degrees. And if your body temperature deviates, you're not coming on the property. It's a ridiculous analogy, I know, but it's just what came to mind. You know, that said, employers still do have some leeway post-COVID, right? So you can still ask people to come back with a doctor's note to come back to work for various reasons. You want to make sure you're applying it consistently, however. to avoid any kind of allegations of discrimination or disparate treatment. You can ask about symptoms or recent exposure, but only when there's a legitimate job-related reason to call for this sort of an inquiry. Like you're in food service or healthcare, or there might be an exposure in the workplace. Maybe you work in food service and you think somebody got food poisoning from something they ate on premises. That might be a good thing to find out and could affect customers and coworkers alike. Or if it's like, hey, you've got the stomach flu, maybe we don't want you coming in. Can you please prove that, you coughing on the meat isn't going to start a norovirus epidemic or outbreak in the office. You can do temperature checks or illness screenings, but only if they're applied uniformly. And again, when there's a legitimate concern, we now have measles running rampant in various places in the country. So who knows, we may be doing yet another infectious disease webinar and revisiting these topics in more detail in the next few months. I guess just wait and see, like everything else these days. And you can temporarily exclude folks from the workplace, but again, it's only temporary and only if they're exhibiting symptoms of a communicable disease, but it can't be you're never allowed back here or without a return to work path. What you can't do anymore, I believe antibody tests are still prohibited by the EEOC, at least as they related to COVID. That I think is still the case. You can't just do random health surveillance without any real reason, just like, equivalent to like a random drug test that might be. So like if you're an over-the-road truck driver, right, who's subject to the FMSCA, the clearinghouse, you have to do random drug tests, but that's something that's like set by statute and federal regulation and is not really considered an ADA issue in the same way. Although there are procedures within that for like shy bladders and whatnot. So I suppose if you did have a urinary tract issue, you could still get an ADA accommodation related to that. You can't single out employees for screening based on stereotypes or assumptions. There were a lot of, let's call them racially stereotypical rumors about who was vaccinated and who wasn't during the pandemic. There were some ugly rumors about African Americans being vaccinated at lower rates based on lingering cultural distrust related to like the Tuskegee Airmen being tested.
Great point.
Surreptitiously in the 40s with all sorts of horrible things. You can't be like, oh, well, you're Black. You must not trust vaccines. So we're going to randomly select you for this job unrelated health screening. Like that's not going to fly. And the other thing is you can't demand broad medical information beyond what's necessary to assess immediate fitness for duty. So these are all, competing issues. I think the nice thing with the ADA is it gives you these frameworks. And unless these guidelines have been completely stripped from the EEOC's website, at least some of this information should still be available to people. Though fewer of these types of guidance that I used to bang the table and say, look at this, are there than used to be.
Yeah, they're there today, gone tomorrow, and then back again the next day or something like that.
Yeah, just keep clicking refresh. It may change a few times.
What about the validity of the procedures that the employer uses? I mean, you can't, you can't test you can't use shoddy testing means or things like that. I mean, what do you, how do you guide an employer, or what do you say to an employee, a pissed off employee in that situation?
You mean like testing their humors and like bleeding them?
Yeah. If you see the TV show Severance, like they're I forgot they have some weird name for that. For that
That's
type
funny.
of
I
thing.
just pulled that out of you know what. I think again, it's sort of like so many of these things. You have to go back to does this have anything to do with the job qualifications and necessities? Is the test you're using something that's scientifically reasonable and tethered to job duties? If it's like going to measure your skull and it's some antiquated racist science that not how
Phrenology.
any of this works that you think is going to be a direct corollary to how intelligent somebody is, I would maybe avoid that. If there's some legitimate reason for what you're doing and you can explain that and you can tether it to reality, then it's a different discussion. But like, don't force people to take ivermectin because you think it's going to stop them from getting COVID. I don't think that's a good idea.
Or drink bleach.
Yeah, or put bleach
Yeah.
anywhere else for that matter.
Ahmed, what kind of reinstatement rights do employees have subsequent to leave? Like which laws apply in these situations?
The short version is they should get their job back. The longer version is there's going to be FMLA issues, but there's also, Helen explained this earlier too. Under the ADA, there can be potential claims as well. There could be state Human Rights Act claims. There could be other local ordinances. And I think companies want to be careful about changing job conditions when an employee is coming back from leave. Not only are those protected, for example, under the FMLA, the employer is supposed to be entitled to the same or equivalent jobs, similar benefit, or the same pay, benefits, terms, and conditions of employment. Separate from that, though, there was a Supreme Court case that came out last year, the Muldrow decision, in which the term retaliation has been broadly defined than it was previously. And so I think generally speaking, companies want to be cautious that they're not treating the employee who was on leave differently than they otherwise were, because that could just open up the company to a whole host of retaliation type claims that are separate and apart from even the FMLA. And then one other claim that I think employers need to be cautious about too, and Helen mentioned this, is FMLA interference claims of you don't want to be seen as an employer of interfering with an employee's ability to take FMLA.
Great. Well, the for reinstatement, can an employee be reinstated to a lesser position but the same pay? I mean, would that be advisable or?
I don't think it'd be advisable. I think
Or-
potentially under the FMLA, maybe that's okay, but I think there could be the employer is opening themselves up to other retaliation claims now. And where I mean that is going to be, I think, more in the context of that Muldrow decision. The way I at least read that is separate from the FMLA. If the employer is changing the employee's job to a degree, that could be a retaliation claim. And so that could implicate federal Title VII type laws, but then their potential spillover to that is also state equivalence. So I think generally speaking, companies should make sure that the job the employee is returning to is materially similar in terms of terms and conditions.
So here's one, like as a follow-up. I encounter this maybe on the average weekly with clients. How long does a business have to wait if the employee doesn't respond to the business's inquiry about, what can you do or can't do, and when do you expect to return? And there's another follow-up to that, but let's go with that one first.
Yeah, I think generally speaking, the leave is not supposed to be indeterminate or for an indefinite period of time. So from an employee standpoint, I think foreseeable leave, you'd want at least 30 days. There's, I guess, two components to your question. How long do you have to wait and how much notice should be provided?
Yeah.
I think from a notice provision standpoint, employees should provide notice at least 30 days in advance if they can. If they can't, as soon as they practically can. I think in terms of when an employee is coming back to work, you want to be careful as an employer because you don't want to be seen as interfering with their rights, but obviously at some point you need to know when they're coming back. And so obviously there's an exhaustion period through FMLA of how long can you actually be on leave. That I think is if the employee cannot come back at the end of that leave period, maybe you add a little bit of a buffer to be safe, but that's probably the best approach.
I think
So I'll throw this out.
law that
I'm sorry,
says,
go on,
like,
Max.
No, I was going to say, I seem to remember some case law that says, like, if you hit your 12 weeks, but you let them know I just need a few more days or I can't get into the doctor, but you have a date certain for return, that, there's a need to accommodate that or work with it. But yeah, I mean, they don't have to just not talk to you for 12 weeks and hope for the best.
Yeah, exactly.
Sure. So here's something I've been dealing with, the real situation. And I'm not looking for legal advice, but
I was going to say, Chuck, you heard the disclaimer at the beginning,
Yeah.
right?
yeah. But to me, this is a novel situation that came up, and it's kind of humorous, I think. The client gets 3 letters from the employee. One letter states that they can return in around 30 days. The next letter states that they're not fit to return at all, and they're all from medical professionals. And then Well, actually, no, I'm sorry, there are two letters. So, and then and the employee tells the client, hey, I disagree. I can't return, within 30 days, at the end of the 30 days, and I'm going to go for another examination. So, what is what do you think the employer does then or can do
This
then?
could be the situation where the employer might want to invoke their own right to get the employee examined.
Yeah. I thought there was a
An
right
independent
to a
medical
tiebreak.
examination.
I seem to think there was a right to a tiebreaker examination when there are conflicting medical opinions, but I can't recall off the top of my head the procedure for that.
Independent medical examination, IME.
Yeah, something to that effect, like where if you
Yeah.
have two different doctors saying, oh, they can do their job, one saying they can't, that there is a process for getting that third opinion. I just don't offhand recall.
So this is what I told the employer to do though. Contact the medical professional who said they could return within 30 days and ask them if they know that there's these other issues and they're saying, hey, I can't return and I'm going to get another examination. So see what the doctor who wrote that they can return says, because you're allowed as an employer, right? You're allowed to make an inquiry, like a reasonable inquiry, not like, not frivolous or anything like that.
Right.
And
If,
and then
and
run
if
the
it's
job and
unclear.
also include the job description, run the job description by the medical professional. So,
Yeah, that
Yeah,
sounds right.
I think that's all right, but I think you want to still be engaging in some interactive process because I mean, you have to do that consistent generally with the FMLA, but also
yeah,
the ADA. And so I think
yeah,
that's where you want to be really careful as an employer is you don't want to be seen as someone who didn't do that because that could just create a bunch of additional headaches and liability if you don't go through that process. And I think so my position on this is generally to be cautious because it implicates so many different laws and so many different potentials and headaches you have to deal with if it's asserted that the interactive process did not occur.
yeah. If the interactive process doesn't occur, I mean I think the employer is screwed basically, because it's in the law.
No,
It's
that I
law.
agree with, but also
Yeah.
separate from that, I think you want to kind of really demonstrate as an employer that you did try.
Yeah, I think
Exactly.
my digging back through some old research, I think it brings you into an ADA context then at that point, because you're sort of done with the
Yeah.
FML analysis, and now you're into the can you perform the essential job functions and analysis.
Good point. Yeah.
Yeah.
And I
Yeah,
think
that's 100% right.
Amit said
Yeah.
this. I'm just sort of piggybacking on it, but yeah, it gets you into you sort of morph it from an FMLA case to an ADA case. The one thing I will mention on that topic is the ADA is not a leave protection statute, and courts seem very eager at every opportunity to remind people of that like if you are smaller than 50 employees as an employer, but the employee requests leave and you don't have to grant it under the FMLA, they can't say, well, as an ADA accommodation, I need 12 weeks off. Like it doesn't work that way. So at least in the Seventh Circuit, I know that to be the case. I think that's pretty consistent in most others.
What
It is.
And
Yeah,
this
it
is true
pretty
for both
consistent.
FMLA and ADA. The employee doesn't have to say, hey, I need you. The employee doesn't have to use some specific magic language or
Yeah.
terminology for the request. So this is also where I think employers should be smart about having internal trainings with their managers about what really is an FMLA or ADA request, because it can be such a headache if it's not followed properly.
Yeah, and that's part of the interactive discussion too, to a large extent. I mean,
Yep.
even if you're not talking about ADA or FMLA, I mean, to at least you need, and I think it comes up in sexual harassment too, because the employee doesn't need to say, the magic word, sexual harassment. They
Yep.
just need to convey the circumstances to you, and it's up to the employer to decipher or to define what it is, what's going on.
Exactly. And they're supposed to work with the employee because the assumption within the
Yeah.
law is the employee doesn't know. They just know they have a medical issue and they need to take some time away from work, but they may not know how to ask for it or how all of this functions. And so that is more on the employer, at least the way the law functions.
Yeah, and I think what I often see when these FMLA cases come up in my practice is often you get some middle manager type who's just so focused on, well, you have attendance problems or this is our attendance policy, and they're not really paying attention to the fact that, well, yeah, but they have a condition and they keep telling you I can't come in because I have this or I have that or my wife went into labor early. This isn't like I'm no call, no showing, like I've got a medical emergency, I've been here for a year and I have this right. I will say one of the other things I often see, and with potential clients, when they have like intermittent FMLA, you know, you want to agree to designated mechanisms for how you inform the employer, like what the process is going to be. And employees are not off the hook. Like they can't just tell their buddy, oh, tell the boss I'm not coming in because I got a flare up or my kid's got a flare up or this thing happened. Like you do actually have to go through the effort and meet your own employee obligations to do what the employer is setting out as the required procedures. Now, obviously, if like someone's on fire or some emergency happens, then you just need to, at your earliest convenience, basically rectify the incomplete notice. But you know, that you can set procedures for how they give you this information. So it's not like a text message to the lowest ranking employee who's not even in that day and they're just off the hook.
Well, I mean, this needs a sort of a question, off the cuff question, but how dogmatic can an employer be? I mean, I've seen in handbooks policies like all complaints have to be in writing, and all like you have to fill out this form for leave of absence. You have to fill out this form for our FMLA form, things like that. I mean, how dogmatic can an employer be relative to things like that?
Employers can have reasonable policies and they can require the employees to follow the reasonable policies. But at the end of the day, if the employee put a supervisor on notice, meaning they said orally, they just said to them in conversation, I am ill, I am not feeling well, I need to leave. That triggers sufficient notice, even if they don't send the form, even if they don't follow the employer's written policies and procedures. This is where sometimes there's a little bit of a disconnect between an employer's policy and the law, because the employer looks at their policy like that is the law. Okay, but that might be the law for the employer, but that not is the law. And courts are going to look at the law, meaning what does case law precedent say? What does the actual statute say? And if the employer's policies are either inconsistent with the actual real law, then courts are going to follow that and will basically say, fine, so they didn't follow the policy. You were still on notice. You're still required to follow the law. At the end of the day, you have to follow the law, whether your employment policy is consistent or not with the law.
Let me just add one quick point on this. Because as a labor lawyer, I know this comes up a lot. If the collective bargaining agreement doesn't address these issues, you have to follow the law. So, the collective bargaining agreement can grant, depending on the nature of the relationship or the agreement itself, can grant greater rights. I don't think they can grant fewer rights, though. So just, if you're an employer out there who's got a labor union, just be aware of that type of stuff.
Yeah, you definitely are the union guru. My expertise is not, the labor per se matter.
So let's stick with you, Helen. What happens if there's a disease or something in the workplace? Somebody gets sick, really sick. What can an employer disclose to the workforce about this? Like a single infection, or even like their own contagion.
Yeah. So this is challenging, and really the size of the employer, not that it necessarily makes a difference in terms of what the requirements are under the law, but it makes a difference in terms of reality. I mean, reality is if you have a small place of employment where there are only like 5 people and someone was coughing and hacking one day and then they're not there, and the employer sends out a notification saying, we have an employee that has, COVID. Like, I'm just using the COVID situation because that's what most people are familiar with, because this is in fact what really happened.
Contact tracing.
Yeah.
Yeah, there was an employee, that it was determined who had COVID, so go get tested for COVID or whatever the case may be. If you have only 5 people in the place of employment, everyone's going to know who that person was without you saying it or not. Now, by law, you should not disclose who the individual was. You should maintain confidentiality because, for instance, under the Americans with Disabilities Act, even though an employer, generally speaking, unless they're like a hospital or something or a medical facility, is not like a HIPAA employer, meaning they don't have to follow the HIPAA laws, there are certain requirements under the Americans with Disabilities Act for confidentiality of medical information about employees. So let's say you have certain medical information about an employee, just because that employee has a disability or whatnot, you've got to keep it in a separate file. It shouldn't be part of like a personnel record. You should not be disclosing confidential health information that you might be privy to. So that would be the same thing as someone who, let's say, contacts the employer and says, I have COVID. You cannot tell other people in the place of employment the exact name of the individual who has COVID. So in a larger employer, some, probably folks aren't going to know the difference if, let's say, someone was, out sick with COVID. But in a small place of employment, even if the employer does follow the specifics required by law of not to disclose confidential employee information, folks are just going to know, unfortunately. And then employers have to be really careful, because someone could go up to the employer and say, oh, we know Sally's out because she had COVID. And the employer has to kind of keep like a little bit of a poker face, because technically they really can't admit that it was Sally who was out on COVID, even though everyone knows Sally has COVID. And that's where there's a little bit of a rub, and that's where it becomes a little, a little bit tricky. So technically, on paper, the employer should not disclose the confidential health information of the employee, but for the protection of all employees, an employer is allowed to advise that someone had a certain type of an illness. If that is something that's going to be infectious, it could infect other individuals, and to protect the health and safety of all other employees who are allowed to take, reasonable precautions in the workplace, require people maybe to hand wash or sanitize or clean, certain areas more thoroughly, because someone, let's say, contracted an infectious disease and was at the place of employment. So it's a delicate balance.
Yeah, and I think continuing on with that, Max, I mean, what if everybody's really concerned about the employee, and in good faith and goodwill, they want to know, and they want to like send their best wishes, or their get well and cards and ever to to an employee or employees, and because they're friends and things, we're one big family and that type of stuff.
It's hard, because this is one of the areas where I feel like in labor and employment law, on the management side or just on the employer side, like people's human or practical impulses run into what the law protects, and
Yeah.
it feel like unnecessarily restrictive or bureaucratic, and I do get it. At the end of the day, think of it like HIPAA. HIPAA only applies in an employment. It's that and the First Amendment are my favorite social media, like, misunderstood laws and concepts of, at a private company, somebody gets fired for saying something horrible, and it's like, oh, it was the First Amendment. And
Not the Second Amendment.
well, that too. But or what is it? Third Amendment, they quarter soldiers in your house too, right? So
Forgot about that
but
one, actually.
yeah, but no, I mean, these privacy protections are there for a reason. If there's really an outpouring of desire of goodwill and a wish to wish well, then go to your employee in a way that does not violate their privacy, and just ask them, is there anything I can or should share with your coworkers? They're asking about you and they're very worried about your well-being. No pressure. If you want this to remain private, I'll just tell them the minimum that I can by law, and move on with it. But put it to them, and perhaps get in writing that they've consented to that as a nice CYA and protection.
Good
Because
idea.
medical information, whether it's COVID or an infectious disease, like Helen is saying, or just an ADA recognized condition that rises to the level of a disability, medical information that you learn through an accommodation request, leave request under the FMLA or otherwise, is just that. It's confidential, right? And you need to treat it that way, with the appropriate sensitivity and confidentiality requirements in mind. You can't disclose the nature of the disability to coworkers, even if they're just trying to help. There's not, the intent requirement isn't here on this topic. What you can say is, Amit's on leave, we're working on coverage. There are schedule changes we got to put in place to accommodate someone's personal need. Thanks for being flexible. We're out of respect for employee privacy and company policies, we just can't disclose more than we have. We're not trying to be difficult. And to Helen's point, sometimes if you work in a 5-person company and 4 people are there, and management goes and says, hey, somebody has COVID, I can't say who, but we all need to get tested, or we all need to do this. Okay, so 5 is a bad example. Let's call it 16, and 15 out of 16 are at work and 1 is missing, because the ADA only covers 15 or more employees, right? Is everybody going to understand the score? Yeah, does it feel a little silly and contrived to be like, can't say who it is, even though there's only one person missing? Like, yeah, I get it. Everybody will know. And all the same, if you ran around spouting that person's private health information, you'd still be in this boat. So the long answer to the short question is be careful. The other thing I will say is there's this notion of like friendship or concern or family. And I've seen this I don't have a ton of management clients, but I've advised some medical practices. And you get situations where a family member goes to the front desk or somewhere and just asks a general question about their partner, spouse, relative,
Yeah,
neighbors,
yeah.
information, and somebody not thinking about it just answers the question. Well, that's if they're not on the list of people who technically have permission to get that info. Was it an honest mistake? Absolutely. Like, would most normal people have made the same error? Yeah, even those who do annual HIPAA compliance training. And yet it's still a HIPAA violation for which you're going to run into trouble. So think about it that way. Like, does this person need to have that information? If not, what am I actually allowed to say here? It doesn't matter how silly it feels. You gotta stick to the guidelines there.
By the way, HIPAA, just explain the acronym, and if somebody can.
Health insurance, right? Health information, patient protection and
Health insurance, no. Health
portability.
Insurance, Patient Portability and Accountability Act, I think.
Yeah,
Health
something like that.
Really
Insurance,
ought to know
Patient
this.
Portability and Accountability Act. I
It's
think.
the House Insurance Portability and Accountability Act of 1996.
We don't
Health
lose our
insurance or health
speakership.
information.
Yeah,
Health
we don't lose our
insurance.
ability to be
Oh.
speakers for not knowing the answer to that obvious.
Well, HIPAA is kind of its own little area or layer of all this stuff anyway. I mean, it's not,
Yeah.
I don't really think of HIPAA as being like in the mainstream of employment law.
Well,
Sort
that
of
was
like workers'
my
comp
point.
too.
Like, it's unless you work in a healthcare facility, there is no such thing as a HIPAA violation in your workplace. There are only ADA or
Right.
Yeah.
small employer
Right.
context.
Employers are not HIPAA, they're not HIPAA entities in general. As I said, unless you're a
Except if you
hospital.
work for, hospital
Right,
medical.
unless you're a hospital or like a medical office, you're not, HIPAA doesn't apply.
Yeah.
HIPAA doesn't apply in the employment context.
Right.
Great, thank you. Amit, on a different track now. What about, can employers incentivize good attendance, like in the same way they would incentivize good performance? What laws would prevent them from doing that?
So yes and no. I mean, employers can give discretionary bonuses. They can have policies based on performance. So they can definitely do stuff like that, and they do. Obviously, someone who's a top-notch performer is more likely to get higher salaries, promotions, titles, stuff like that. What an employer can't do is basically treat someone differently based on they needed leave, or maybe a perceived or actual disability, or protected class status, or hypothetically or allegedly, in retaliation for something. So that's where employers have to kind of draw the lines, but they can definitely have policies that are giving additional benefits, compensation, etc., for their employees who perform very well.
So let's flip that, and I'll address this to all of you. What about taking disciplinary action for, or some sort of punitive action against employees who they think are abusing the system? Like I guess the most egregious or obvious example, like taking every Friday off or every Monday off.
Yeah, the law doesn't protect people who aren't doing their jobs, or cannot perform the essential functions of their jobs. What the law does ultimately is it just protects people from being treated differently based on some protected class status or exercising legal rights. And so an employer can discipline or ultimately terminate an insubordinate employee or an employee who's just not showing up to work. But what an employer can't do is take someone who it's terminate someone who just took FMLA leave to care for a parent or a partner or a spouse, or took their own, or has their own serious medical condition.
And I think it speaks to the, like, I joke that I'd say this once a webinar, but like why it's so important to have good documented and consistent practices when you deal with your employees, which again can feel like annoying red tape and wasted time. But if somebody has attendance issues and then goes on FMLA and then does something else, you want to make sure that you've papered the file in the right way, honestly, if it's an issue, so that some lawyer like us doesn't go and say, oh, look, an FMLA interference or retaliation claim because this person's been documented being hung over every Friday in perpetuity. And the fact that they now manage to, like, now they actually have a legitimate reason, has no bearing on the fact that they missed every Friday for the last 6 months and had been warned in perpetuity. And, their firing was just coincidentally timing wise.
Well, and you
And
make a, gotcha, go ahead.
I just want to add, I think the documentation stuff is even more important now than it used to be because of the Supreme Court decision in Muldrow.
Mhm.
The way I read that decision, I think the definition of retaliation it is broader than it used to be. And so I think employers want to be more thoughtful about, look, if there is a repeated history of issues, is there some way to establish that? Because then if the employee does take leave or does something else, the employer can say, no, the separation isn't because of these or whatever change in job conditions has nothing to do with this activity. It's because of all of these other things that were happening.
Well, and we've discussed this too in prior webinar. I think wage and hour compliance or showing the money that it's up to the employer to maintain documentation and maintain attendance records, even for salaried employees.
Yeah, and just for straightforward reasons of like you've got to prove it. And one way to prove it is
Yeah,
if you have a bunch of emails or other records, it's just say, hey, here's the documented steps we have taken to try to, prevent this type of stuff from happening. It's just better for the employer then because it'll just be easier to deal with someone sending them a letter from Max if they can say, look, no, here are all the emails we were sending on this issue.
all
And
right. So I'm sorry, go on.
no, I'm just going to be piling on to agreeing with Amit. That's okay. We did that enough.
Well, here I have a meta question like in the last minute for you guys. Um, any predictions, now we have, we're in the age of Trump and it looks like we're in the age of deregulation. So what do you think that we're going to be getting rid of some of these like employment laws, these leave laws, things like that, or not necessarily getting rid of them, but making them less stringent?
Not the
So
major ones. Oh, sorry.
I'm sorry. You
I
go.
think the major laws are not going anywhere. When I say by the major laws, in principle, the Family Medical Leave Act, the Americans with Disabilities Act, the Pregnancy Leave Act, what is going to be chipped away and what we've seen has been chipped away are the agencies
Yeah,
and how they interpret the law. So, for example, I can't think necessarily of a disability related one off the top of my head, but the one that really comes to me at the top of my head is, for instance, the Department of Labor.
Yeah.
They wanted to change the salary basis to be considered exempt. I mean, it's a really, really low amount. And so that was supposed to be raised. That was supposed to go into effect. It did go into effect and it was later rolled back. So things like that I could see changing. So how we interpret the law, perhaps, because often the courts rely on the agencies to interpret the law. And with the change in government, I think the agencies might interpret the law a bit differently and roll back their own, let's say, policies and interpretations of the law. And so I think perhaps how we understand the scope of the law might change, but the law itself, the major laws, I don't see them going away.
I have a hot take on this one, which is I'm not even sure it's that hot anymore. This Supreme Court has surprisingly been good about expanding their interpretation of employment laws. And what I mean by that is they've read into Title VII to mean that it applies to LGBTQ type protections and sexual orientation. They had a decision about a year or two ago expanding rights for religious discrimination in the context of employees. There's a case right now pending with the Supreme Court about what's called majority discrimination, i.e., is there a different test that's going to be applied to people who are in a majority group versus a minority group? And then you have the Muldrow decision, which I keep referencing. I think the combination of all these factors actually means it will be easier to sue an employer for discrimination matters. Helen is also right, though, that there is this tension between what the Supreme Court is doing and then what the administration is doing, or the executive branch, which is gutting a bunch of federal agencies. So on the one hand, you have an expansion of the interpretation of these statutes. On the other hand, you have a decrease in resources to deal with the volume of these issues.
great. Well, if there's nothing else, we're at the top of the hour. Thanks, everybody. It's a great discussion, great analysis. And to all you out there, our attendees, we're going to be back for webinar number 5 I know what you did last summer, workplace investigations. That's going to be on June 5th, 2025 at the same time, and that'll be on a Thursday. So yeah, this is an aberration that
Oh my
today's
God.
being
My
on a
son's
Wednesday.
graduation from 8th grade, June
Well,
5th.
Congratulations.
Thank
That's
you.
huge.
Yeah, we're not gonna go must patch 3 o'clock. I gotta be down in Hyde Park by 4:30 that day.
It's okay.
Oh, Helen,
Take
didn't
care.
tell you that's the special 3-hour episode.
Well, take care,
I'll
everybody.
only
We'll
take
see
a third
you,
of it then.
Bye, guys.
see you next month, okay?
All right.
Bye, everyone.
Bye.